Yes, well, we've got a couple more areas we might just want to explore with you, Mr. O'Brien. Have you got more you wanted to say for yourself?
I just want to, you invited me to agree with the others in the case, the sequence of events.
Yes.
Mr. Justice Poole in part deals with this paragraph 15 of his judgment, page 88, but the actual detail is as follows. Dr. X gave evidence on the first day, which was the Wednesday. And we didn't start immediately because, as the learned judge says, Mr. Mike O'Brien, case he needed time to take instructions from B. Later that morning, he was able to tell me that, having said for many months now that she would not be a party to administering HRT covertly in her or otherwise, B was now prepared to collaborate with covert medication, but not to deliver the medication.
Yes, thank you. Yeah.
And that's what we dealt with on. So we dealt with Dr. X's evidence on the Wednesday. On the Thursday, we had a 10:06 start when B gave her evidence, and that was into the afternoon of the Thursday. And then on the Friday, V, the social worker, was to give evidence. We were due to start relatively early, again 10 o'clock, but Mr. Mike O'Brien, client, didn't attend at court, and she was for a period of time uncontactable. She was then contactable, and as I recall, one of the solicitors, I think, attended upon her in her hotel, where she explained the circumstances outlined there. She suffered an accident requiring hospital treatment overnight, and that she would be attending. She was hopeful that she would attend court. In the time that we were waiting, I think this is important, the suggestion was that we would not hear the social worker's evidence at all that day, and then we'd look for a part heard day to go to. We identified a day.
Out of curiosity, why was it? It was just everyone agreed it would be wrong to proceed in B's absence.
I think that was at that stage, Mr. Mike O'Brien's application that B should be there for social worker's evidence. Yeah. So there was a delay just finding out what happened. We identified a day, which I think was the 17th of February, as I recall, when we were free. But I think the judge had a matter already listed there, and so we then got the message through that the judge had decided that he would hear the social worker, and at the same time, at 13:53, the learned friend, Mr. Mike O'Brien, said that B would be attending at court, but that the social worker's evidence could start immediately, even though she wasn't there.
Yep.
And then in the afternoon, B attendant came into court whilst the social worker was giving her evidence. And I think the social worker's evidence was around about an hour and a half-ish, maybe a bit sort of up to the 3:45 level.
Someone was obviously making very good notes with timings, but anyway, yes.
So that's where we were, and as the judge then says in paragraph 16 that parties needed time to produce their written submission.
But had it been envisaged, then, as what I hadn't really taken in, had it been envisaged that on day 3 there would have been the social worker's evidence and straight into closing submissions in the afternoon or even the late morning? Yes, I see.
Yeah, but there was no doubt in anybody's mind that on the Friday it was anticipated that we would go to all the submissions.
There then wouldn't have been any written submissions.
There wouldn't have been written submissions.
No, right.
Probably why you were going to start at 10, wasn't it?
I think it was.
Deal with social workers' evidence and to give you all sufficient time to make your oral submissions.
Yes, I think the judge probably looked at who was on the front row and thought the 10 o'clock start was probably justified.
I won't unpack that remark.
Me.
Yeah, no.
Hesitate to interrupt. What was in prospect is set out as it happens in paragraph 4 of the local authority's opening written argument. And you'll find that in the supplementary bundle at page 2.
Yes, I see. Well,
I don't know why.
yes, I see. So the social worker would have given evidence on day one. Yeah. Anyway, I asked for the details. I'm not
Yes.
complaining, but I think that is more than enough detail.
Yes, thank you.
I just wanted to get a better overview. Thank you. Yes.
But
Now,
nothing further from me.
right. My lady, I know, wanted to raise
Yes,
something with you.
just before the short adjournment, Mr. O'Brien, you gave us some headlines on deprivation of
Yes.
liberty. It's an area you're not wholly unfamiliar with.
I'm not unfamiliar with it, no.
And I wondered if there was anything you'd like to elaborate on, or just given a little bit more time.
No, I mean, the fact is that following the decision in Cheshire West, there was obviously a huge growth in the number of people who would be covered by the objective test, the acid test. And that meant that the settings were not just focused upon, for example, care homes, nursing homes, supported living places, but that a person could be deprived of their liberty in their own homes. And the test is, for determining that, is essentially the same, which is the subjective test, which is the inability of the person to consent to the arrangements which amount to deprivation of liberty. The objective test, which is defined in Cheshire West as being what's called the acid test, is a person under continuous supervision and control of their carer or carers and not free to leave. And are those arrangements imputable to the state? And that is essentially the test that's approached. And we sometimes fall into the habit of talking about Cheshire West defined deprivation of liberty. It defined one part of the test, which is the objective test, the acid test.
Was the judge addressed on the relevance or otherwise of deprivation of liberty at home for his welfare decision?
No.
And I mean, just looking at it at a very great distance, if it was a question that had to be asked, and if it transpired it might have to be asked by a local authority, the sort of circumstances that A would return to if in the care of B might call for some inquiry,
Yes.
but it wouldn't be clear where that inquiry might end.
No, and in fairness to the judge, he had identified the essential parts of the concerns a local authority would have about somebody being deprived at home, which is the enmeshed relationship, the inability to access services, the unwillingness potentially of B to cooperate with the care plan. All those are matters that you would normally look at and say that is a deprivation of liberty, which is very difficult to see how it should be authorised, because it's difficult to see how that could be in some necessary proportions and in somebody's best interests, which is the way we tend to look at deprivation of liberty. But he had, in fairness to the judge, he had identified the factors which would point against the deprivation of liberty being authorised at home. But we had not had the opportunity of addressing him on the legal framework.
Well, you say you didn't have the opportunity. I mean, let's suppose the fact that A would be deprived of her liberty at home in the view of one of the parties was a significant factor in the welfare analysis.
Yes.
Then it wouldn't be okay just to leave it until the judge had made a decision and then pop up and say, but that's a deprivation of liberty. It would have to be something that was argued as part of the welfare argument.
It would have to be argued as part of the welfare argument.
Yes.
It would be, if that was the option that was being seriously considered by the court, it would have been the subject of discussion, submissions, argument by the relevant parties, the local authority, the officials, potentially.
Yes, but I understand that, but it's a question at what stage. since everybody was lined up in order to say, in response to B's application, A should not go home.
Yes.
I mean, if anybody thought that it was a good argument to say A should not go home because she'll be subject to deprivation of liberty of a different kind to the one that she currently experiences,
Yeah.
that was for them to say, surely.
Again, in principle, I would say yes. But what we were looking at then is the difference between them is you're looking at a 12-week deprivation of liberty on the basis of a trial, as opposed to a deprivation of liberty which, according to the order, you've then got to determine how often is that reviewed, what are the circumstances of the review. So we know from a case called Salford City Council and BJ, which was a decision of Mr. Justice Mumby prior to the commencement of the MCA. And it was an inherent jurisdiction case where he said it would be wrong for the inherent jurisdiction to adopt a period of time for authorisation of deprivations of liberty, which were greater than the then proposed statutory scheme in Schedule A1, which only has 12 months. So you'd be looking at the 12-month period, you'd be looking at what the nature of the reviews were, what would you be looking at, whereas that is, my lord, slightly different to a 12-week deprivation of liberty for the purposes of a trial.
Thank you. Yes. Could we go back to the submissions that you were making before lunch about what would have resulted from an argument
Yes.
being heard before the judge made his final decision?
Yes.
I mean, obviously, when you say a discussion of that sort has value, one can easily see that it has value. But could we try to identify what, in the particular circumstances of this case, that value would have been? What topics might have been touched upon that that you might speculate would lead to the judge having reached a different overall conclusion?
Well you would have been informed, or you would possibly, if we had been told that the judge's view was that, as a starting point, he wanted to bring the deprivation of liberty at the care home to an end and return her home, which was a major factor in his judgment, as I read it. You would have been then asking, what's the MDT's view of that? How should you would want it to have drawn down?
Can we make a as it were a list as you go along as you're thinking of things?
It would be a very difficult list to follow them all.
Right. Well, I think.
But one is the MDT. You would want the MDT involved.
Sorry. Yes.
No, my apologies. I mean, the judge really makes no reference to the MDTs in his judgment, does he?
No. He had a member of the MDT, two members of the MDT, giving evidence, but they were only two members.
Dr. X and the social worker.
And the social worker. He did, in fairness, have those two, but he makes no mention of the value of the MDT process in terms of informing how the case had gone on, was going forward, or could go forward. So the MDT is definitely one significant factor which we would have invited him to at least consider in the light of what he was thinking.
Consider what? The views of the MDT. He says in his judgment that although he'd only heard, as he put it, from Dr. X, but actually he'd heard from Miss S as well.
Yes.
He would assume that the views of everybody involved in both the medical and the pastoral care of A were the same. So what do you mean by?
You would be giving the MDT a more concrete basis to give their informed view by saying this is what the judge is really thinking about now, which is a return home. How can that return home be secured with the?
But your entire, I mean, not yours, but I mean, talking about collectively,
yes.
The entire case was she shouldn't return home.
Yes.
It's unsafe for her to return home.
Absolutely.
Well, I mean, the social worker's statement was her 17th.
Yes.
I mean, what more is needed than having the view of the social worker, having the view of the consultant? I mean, the decision maker here is the court.
It is the court, but the court would not act in isolation in a case such as this when it has relied over time on the MDT, on Dr. X and on the social worker.
But you're not surely suggesting the court was acting in isolation?
No, I'm not, because it had heard from Dr.
But I mean, apart from saying
X
that you should, I mean, it's been put in without some adjectival way in some of the submissions about directional as opposed to collaborative.
Yes.
I mean, is that what lies behind this submission, that there ought to have been some more collaborative approach, rather than the court providing direction?
I think the submission I made is that if we had been aware, I'll be blunt with you, if we had been aware that the judge was proposing and telling sending her home, we would have been wanting to persuade him of the difficulties and the dangers over that.
But even on her case, you had that opportunity.
Well,
I mean, what's the difference, in a sense, in the dangers of going home? There'd be plenty of dangers in 12 weeks. Be breaking up what, for good or ill, she's been doing for the last 5 years. I mean, I welcome bluntness, but
yes.
I mean, just simply, from my point of view, simply saying should deal with the MDT.
Yeah.
To what end in this? Giving them another opportunity to say what they've been saying all along.
Well, it may not have done. It may well have been that the MDT, knowing that the judge is saying, well, I actually want to send her home now.
So the judge has got to as it were, send a draft judgment and then invite comment.
No. In exchanges, he may wish to have done that with us.
Well, it seems like right. We've had the MDT. What other products of the desirable submissions should we be thinking about?
Well, as I say, one is the issue about deprivation of liberty.
Right. So we've got the MDT. We've got deprivation of liberty.
One is as well as knowing about what the concrete plan would have been, and what would it have looked like.
But was that not something that a judge of this specialism, helped by counsel of this specialism and witnesses of this kind, knows what's out there? And of course, it has to be tailored to the particular case. But the judge knew the sort of services that were likely to be available to a greater or lesser extent.
Well, I adopt what Ms. Gollop said earlier, that a judge may well, in most cases, know what a support plan looks like under the Care Act. But this was a plan that was designed to mitigate what were regarded as being the harshness of living with her mother. That is a very...
What's the discussion going to consist of? Simply the state actors putting flesh on the bone of what the court knows is available in any case.
All I say to them, my lord, is it may well have been an opportunity for the judge to actually reflect whether that was in fact the right decision to be making.
But if you read his decision as accepting that he was sending her home with all the risks, as he put it, that involved, what difference could it make to his decision?
Well, because an essential part of that was the plan to mitigate the harshness of what life would be at home.
But I mean, what sort of information would the judge have received by having done it the other way around?
He may well have received information that that plan, but there is no way of mitigating those circumstances at home. We simply can't do it. And that may well have persuaded the judge, in fact, that I should not be making this best interests order at this point. And as I say in my written submissions, you have B here, who does not, in truth, buy into a daughter's lack of capacity. She doesn't buy into any of the importance of regular health checks. I suppose the high point of my submission is the opportunity to have the exchanges with the judge before he had made the ultimate decision is what we were deprived of. And it may well be said, as has been said by the court earlier, well, these are factors that the judge had to give proper weight to. Well, in our respectful submission, he may well have given further weight to it and his overall decision if he had known and we had had the full exchanges that one would normally anticipate in a case such as this. As he identified, complex.
Could we look at paragraph 88 together?
Yes.
It comes at the very end where the judge has already been through the sequence of questions, 5 stages about the HRT issue at paragraph 85. And then comes paragraph 88, which is to do with the implementation issues.
Yeah.
Looking at that, what are the issues that arise? I mean, firstly, does that encapsulate the sort of topics that need to be considered in the context of a return home?
Unquestionably, yes.
And
one of which, if I may say, which is important there, is access to aid by healthcare professionals and the administration of anti-epilepsy, vitamin D medication, as well as any provision of HRT tablets for her to decide whether to take.
Yes. So what would what might the discussion have entailed on those issues?
How was that going to happen?
How was what going to happen?
The access. If B, for example, refused entry.
Well, at that point, presumably, if B said, "You've made the decision that she's coming home, but now I'm telling you, contrary to what I've told you before, in evidence, I'm not going to let them in." What's the consequence of that?
But I'm talking about after she's gone home. What is the consequence? What should the state protectors then do?
Well, there's a plan which is endorsed by the court. After a hearing, everybody's got a bit of paper or more saying what that consists of. And at the point where that plan is flouted, at that point, it has to be looked at again.
But by then, you've told her that she's being covertly medicated.
Yeah.
That the prospects of her being removed to another placement would be traumatic for her, with a more increased deprivation of liberty. Because it would be more intense, she would be more resistant to it. Her wishes and feelings would have been more significantly against where she was.
So you're already saying there are no effective sanctions. Once she's gone, anything else will be worse. That's is that necessarily so?
I don't think I'm going that far, but I'm saying that is a risk that needs to be addressed in such a plan.
The judge will have been aware that, suppose, for example, although of course it's where most of our focus is, the HRT medication.
Yes.
Suppose it was clear that she wasn't getting her anti-epilepsy medication. It might well have been the judge. That might well be a case in which she had to be returned to some sort of care, certainly taken out of the care of her mother.
Possibly so.
The judge doesn't, probably for reasons one can understand, allude to that, but he would have been well aware of it.
He may have been, but the point I'm making, with the sort of mature exchanges that we are having about what goes on the ground here and what the consequences were, he may not have made the decision that telling B immediately that she had been covertly medicated was in her best interests. Stopping it was in her best interests. Or indeed making the decision that she return home was in her best interests, without knowing what the actual precise plan would be in relation to these issues.
What are the precise planning parameters of these issues?
But what I've just said, I mean, it includes the aspect of her having access to healthcare professionals.
Yes.
But it's beyond that. It's what if B resists. One of the features of this case, my lord, is that B will say, because she does not accept that A lacks capacity. These are B's choices.
But that's the solution for that is she never goes home. I mean, if that submission holds, then she never goes home. It keeps her safe in some way for as long as the covert medication goes
on the basis of this order, my lord, you've rushed to the decision about returning home without knowing what the full consequences are, because you don't know, for example, what service provision can be delivered to A in a house, what the likelihood is of the ability of healthcare professionals to engage with a mother who is reluctant to let somebody into their house.
I think the judge is surely in a position to make judgments about that.
He would have known about it.
Yeah, but isn't it a matter for the judgment of the judge in this situation as to the extent to which this has to be managed, the detail with which it has to be managed at each stage of the process?
It is. I don't dispute that.
These seem to be, I mean, there's a lot of uncertainty about what would happen in any scenario for this young person. None of it terribly easy to contemplate.
Yes.
But these sorts of things are sort of known unknowns, as it were. But maybe they're the opposite in the sense that we know we need a plan for visiting. Just a question of everybody working out what the best plan for visiting in this situation is. We know that we need to have a plan for provision of medication, just like there has to be for anybody in need of it. How are we going to go about doing that?
Well, it goes beyond that, my lord, on the ground. It's all about the feasibility of that plan.
What's unfeasible?
Because if B does not cooperate...
Well, if B does not cooperate, then the plan may very well have failed.
Yes.
But it looks as if there's a search here for a plan that's bound to succeed, and those plans don't exist in these cases.
Well, in my respectful submission here, you did want a plan that was going to succeed for this.
No, but it's looking for a plan that's bound to succeed.
Well, not bound to... Everybody wanted a plan that would succeed, because the consequences to her of not taking the HRT are significant still.
Well, I suspect.
That's all I wanted to
Yes,
say.
I know. It's always been a very helpful exchange. Yes.
In many respects, it is less the 12-week trial period. It is more the cessation of covert medication and informing A. And it really is the consequences of informing A. And then a complete breakdown of trust between A, healthcare professionals, local authority.
Yes.
Those are significant factors.
They are significant. No doubt about that.
And those are factors which weren't fully accounted for.
Indeed. Yes.
I mean, the judge certainly did think about this. Because of the careful sequencing which he proposes in para 85.
Yes.
But you say he didn't think about it in quite the way that he might have done had it been discussed in oral submissions.
Yes. Can I just say as well, my lord, he did say at 74, these protective measures can be included within the plan for the future care and treatment. But it's the detail of what those protective measures are.
Yeah.
Which is important.
As I say, I think we've now explored that helpfully. Unless either my lord or my lady want to ask about anything else, we let your namesake get on his feet.
Well, I've had more than the 45 minutes I was...
Everybody, is everybody taking more time than they
I didn't intend that.
No. It's entirely our responsibility, not yours.
Well, thank you for listening.
Lady, my lord.
You're the only person who may have less, but I don't think it will be to your disadvantage because so much has been explored already.
Yes. My lord, my lady, I'm obviously in the position of defending the judgment reached, particularly paragraph 82, which summarises the judgment's outcome. And the way I intend to structure my remarks is to make some introductory remarks first, then to briefly touch on capacity, although Ms. Joseph O'Brien has not dealt with that today. His position statement does mention it. So I'll
You mean it's still an argument for this hearing?
My proposition will be it's not an argument for this hearing, and it wasn't an argument for the
Oh,
hearing.
I see. Sorry, but when you said his position statement, I was just confused. He hasn't got a
Sorry,
position.
his skeleton argument for this hearing, yes. I did mention it, so I was just going to touch on that briefly. Then deal with the judge's use, because I'm defending the judge's use of law and procedure in general terms. Touch on some of the issues raised. Then deal with the reasoning of the judge on the factual issues, particularly on covert medication, residence and wishes and feelings. Then deal with the particular grounds of appeal of the applicants, the appellants, and then I was going to touch obviously on the other matter of recommendations, but I don't have to do that.
Off you go.
So it might assist the court if first of all, I set out the general proposition that I make on behalf of B, which is that the judge was best placed to make the decision. He had heard the evidence. He had managed this case for 18 months. He understood the decisions. He referred repeatedly in his judgment to the conclusions of Her Honour Judge Moyer, and he was well aware of those judgments and used them, one might say, liberally in his judgment. He exercised his discretion in relation to Section 4 of the Mental Capacity Act 2005 to reach a best interest decision in relation to A based on the evidence before him. Paragraph 82 in the view of B is in the best interest of her daughter. It's not exactly what B asked for at the hearing in January, but it is in the best interests of her daughter as a whole to return home, bearing in mind that the position of B is that she believes that she will convince her daughter to take HRT. So that is where she is coming from. The judge...
You can't go behind the findings of the judge, which were that you wouldn't.
No, the judge took a different
Unlikely
view.
to.
Yes, that B would try, but he had some doubts as to whether that would be successful.
But I'm not, that may be understating it. I'm not sure he thought he would really try, but...
Well, certainly the position of B, whom I represent, is that she was very strongly committed.
Yes, but this is an appeal. You're stuck with the judge's findings.
Yes, I'm defending the outcome of the hearing. As far as the judge's factual criticisms of B are concerned, clearly those raise serious issues that B has to bear in mind in terms of the outcome of the hearing and the decision the judge has reached. But B's focus remains on her daughter and what's in her best interest, and mother believes that it's in her daughter's best interest to come home and take HRT. So that's where she is coming from. Any weight in the decision, and that's been a big issue during the course of the morning, but is also in the appeal, is for the judge. So he has to make a decision, providing it's reasonable and justifiable to some extent, as to the weight he attributes to various issues. And he was well aware of the findings of Her Honour Judge Moyer and the weight that Her Honour Judge Moyer gave to various factors. As far as clinical opinions are concerned, in the end, it's a matter for the judge to look at these matters as a whole and take a view, having taken into account in full, and this judgment shows that that happened, the views of clinicians. My lord, my lady, at the centre of this case is a young woman, 25 years old, very vulnerable. She has a mild learning disability and Asperger's syndrome. She understands where she is. She's got some idea about why she's there. She wants to go home. She's been in very stringent, even draconian, and that's the word used during the course of these proceedings, restrictions for at least 2 years. The restrictions on her contact with her mother are still quite onerous. So when they meet, and as I have indicated previously, they don't meet very often these days, but when they do meet, there are 2 carers present. The 2 carers make detailed notes of everything they say, and therefore the whole contact arrangements between mother and daughter are very difficult for both of them, very stressful. The carers, in order to hear what they say, and the learned judge indicated that B was a somewhat timid witness and doesn't always speak loudly. The carers stand very close to them. So those are the sort of circumstances that we're dealing with. Now, there's no protest from B about this, because B knows that one of the accusations she could face is, you told A about the covert medication, and she doesn't want that accusation. So in one sense, it protects her. So lifting that restriction has not been sought by B. So it's not a criticism. It is a circumstance that the court should understand. This is what it's like being A. And as far as B is concerned, B has faced a lot of criticism. She is herself quite vulnerable in the sense that she is a victim of quite serious domestic violence in the past in Northern Ireland. I won't go beyond the evidence that she has given to the court. She's found it very difficult, as the court indicates, to give that evidence. Found it difficult to even mention the word Northern Ireland. The OCD she suffers from is managed, but it is something that she's had to live with for many years. It doesn't particularly affect her relationship with A, but it does affect anyone coming into the house, and she finds that very difficult. No one suggests that mother doesn't love her daughter, but there is a lot of evidence about the flawed relationship between mother and daughter. And therefore, in terms of this judgment, there is much that B needs to reflect on. As far as the judge is concerned, Mr. Justice Poole knew the factual background of the case. He was someone who had made some decisions previously. He was well aware of all the circumstances which had arisen, and he was also aware that this was a case where there had been a lot of adjournments. There had been a lot of another 6 months, please, and we'll convince her type adjournments. And there had been attempts, genuine, valiant attempts, by the local authority, the MDT, and others, over 5 years to encourage A to take HRT. And it had failed over 5 years. And the judge concluded there was no reason to believe that it was likely to succeed in the future. There were various adjournments over a long period, and the issue before the judge was that this was a complicated, difficult case. The outcomes were very unclear to any of those in court, and we had to see what the judge would decide. Nonetheless, what we needed in my submission was a direction, to know this is what you've got to do and this is where this case is going, because there were so many potential outcomes suggesting to the local authority and others that I want to see a plan if she goes into SIL, I want to see a plan if she remains in this accommodation, I want to see a plan if she goes home. Would it be a plan with covert medication? Would it be a plan without covert medication? What were the circumstances under which we would get some direction here? And because at the point we started the hearing in January, if we were to say, well, we want a plan for everything, we would have had multiple plans. And in those circumstances, what the judge was seeking to do in a hearing of limited time was to narrow the options so that we could then move to a further hearing where the judge could look at some practical options by way of managing a future outcome. After 5 years, there was a real risk in my submission that this case would drift because of the level of complexity. And the judge took the view that he was not going to allow that to happen, and that there was a need to decide what direction this case was going, where A would live, not only where A would live, but what would happen in terms of the covert medication, which of course was an enormously serious breach of her rights, justified and had a positive outcome, but it was still something which would potentially, for decades to come, if the local authority and others had their way, be an ongoing breach of her rights of which she was unaware. And that is a very concerning situation. So the judge had to also bear in mind that there were reasons why A had been taken into care. To bring on puberty, well, that had happened. That was done. To ensure that she voluntarily took HRT, that failed. That wasn't being done. To ensure that she had greater engagement with her peers in social situations, that wasn't being done. So after 5 years, the judge had to look at the practicalities of why A had been taken into care. The key reason to bring on puberty had been delivered, that was done. The other two had failed.
Well, failed certainly insofar as greater engagement with her peers may perhaps be a harsh description, because there had been an improvement in that situation. And then there had been a change in certainly A circumstances. Face-to-face contact with B was resumed. And it was from that time that others who have spoken in this case say that there was then the reduction in engagement with peers.
The reaction to that B made was that from what we could see, there was very little engagement anyway. Even the local authority did not suggest that, other than a few walks along the beach, that in previous years, and we're talking here about 4.5, now more, it's 5 years now, that there'd been little or no engagement outside the care home. The only engagement that B seems to have had was some mixing with staff in the care home, some walks with staff down a beach, I think on 2 occasions, and beyond that, there doesn't appear to have been much. And we're talking about years. And so when we talk here about the level of social engagement, and one of the reasons for bringing A into care was that her level of social engagement would increase. No blame on the local authority as such. It is that A didn't want that. A didn't want to engage with that. And the reality is that, in fact, she doesn't seem, I'm not aware of any evidence that much more was on offer for her. At least when she went out with her mother for a short period, there was engagement with a bowls club, a local bowls club. But that was stopped in October of last year, from November of last year, because there was concern that perhaps some of these people who knew her from the past might ask questions which might lead her to then ask questions about covert medication. So what we're looking at is not only a level of very low social engagement whilst in care, but also that when she did go out with her mother, social engagement, there had to be restrictions on what social engagement she could be involved in case some people that she knew before might ask questions. So these sorts of situations are clearly extremely difficult, and if we were looking at the future in care, then it is very likely that quite draconian restrictions would have to be imposed in the future in care upon A. Because, my lady, the concern would be, no doubt, that somebody would raise something if she met anyone she knew from before. Now, of course, there has been criticism that she wasn't particularly socially engaged in the past. And B does not deny that that's a valid criticism. She accepts that she ought to have done more in this area. However, she says each day with me, she went out to town, she did go to restaurants, she did see family, but she didn't have peer group engagement, social engagement, from the age of about 9. So those are criticisms that can be levelled at mother, on which mother has had to reflect. Mother says, I accept that if my daughter comes home, that the local authority will now have to provide support workers, and there will be greater engagement by me and also by the support workers in getting A involved in the community. Those are my instructions. That's what she says. That's what she accepts. And it would be surprising, my lady, if a mother after 5 years to reflect did not realise the enormous power over her daughter and herself that the courts have. And she would know, and her instructions were very clear, that she knows that if she failed to deliver on a better life for her daughter, what would happen? The local authority would very quickly make an application to return A to local authority care. And therefore, she is on her mettle from the start. She has to ensure that she does her best. She can't promise that she will get the daughter to take HRT, but she certainly has got to try very hard. And we know that the person that A trusts most in the world is her mother. And the person who's got the most influence on A is her mother. So the person who's got the greatest chance of getting A to take HRT is her mother. So we know that. So A isn't promising she can do it, but she believes, and that the evidence to the court was that she believed she would be able to do that, and she would be able to exercise that level of influence. Now, the position of the appellants in particular, but also Mr. Joseph O'Brien, is difficult, or at least the trust, rather than Mr. O'Brien himself. But they say there's an enmeshed relationship that the level of influence that B has is greater than you would expect from a parent. And of course that does mean that if there is that level of enmeshed relationship, that the person who's going to best influence A is the mother. And if we accept the outcome of this case and the judge's view that he accepts the characterization by Her Honour Judge Moyer of an enmeshed relationship, and he does accept that therefore, if anyone can do this, mother can do it. And mother says she believes she can do it and she intends to do it. So that's the position that the judge was faced with. The judge was very skeptical about whether this could be achieved. I can't go beyond the judgment in terms of what his thinking was. Was it that A was just so intransigent that she would never move, or was it that mother just wouldn't deliver? It may have been the latter. Certainly his criticisms of B were very strong. So it may have been that. But either way, what's the best chance of changing this young woman's life? It is if HRT is given, and what's the best chance of that being given and accepted voluntarily? If mother convinces her to do it. And that's the position. Now, in terms of where we were in January, at the start of the hearing, the court's objective, as I say, was to narrow things down. As far as stopping HRT is concerned, that was not something that any of the parties opposed. Sorry, stopping the covert medication rather than the HRT. Stopping covert medication was not actively proposed by anyone. But can I take, my lords, my lady, to my position statement before the hearing, so that in the supplementary bundle at page 51. At the bottom of paragraph 57, it says there, B argues that the key to getting A to take medication voluntarily is to allow her to come home and to allow B to try to convince her and to allow A and B to organise the visit to the second private doctor. Therefore, B thinks that even if the court concludes that covert medication needs to continue and that covert medication cannot be delivered in the community, then A should be allowed to return home and B should be allowed to deliver the plan set out above. So that was flagged. It wasn't emphasised. It wasn't the position that B took. B was prepared to have covert medication in the community. Let me now take you to my submission after the evidence, when we'd heard evidence from Dr. X in relation to the consequences of stopping HRT. And that's at page 122 to 123. Just to set the scene here, if you take the page before, which is page 121, what was being done in this part of the submissions was to set out the various proposals that were favoured, there were four, by B. And having gone through A, B and C, I came to D on page 122 and said the next option is not the preferred one by B, it is to stop HRT, stop the covert medication in effect, until B can convince A to take HRT voluntarily within weeks. And then the rest of that paragraph D, which goes over to paragraph 18, deals with this issue and looks at the consequences of it in terms of the evidence. I'm not going to go through all of that because it includes notes from my instructing solicitor, which were referred to, and the judge will have his own notes, which he will have been able to refer to in terms of the evidence from Dr. X. The only point I make here is that as far as B was concerned, as far as this advocate was concerned, this was an issue before the court. Ending covert medication was something which was not advanced as the best outcome by B, but it was an issue being canvassed by the court. Therefore, the suggestion that there was no one thought about this is just, that's contradicted by the submission of that.
Is this E at the
Lord's-
bottom of paragraph 17?
Sorry,
Sorry, you just put it away.
yes, it's D.
Submitted.
It's page 122 and
But
123.
all of that is
right
leading up to
E.
the submission made at the end of that paragraph.
Oh yes, sorry, that's just a submission. That the E shouldn't be there. So that's not another one submitted. Although stopping is the least preferred of the four options, she thinks it's better than no plan to get A to take HRT voluntarily. The absence of carers would not prevent A returning home to be convinced to take HRT. So that coincides with the position adopted throughout by mother, which is that I'm the best person who can convince my daughter.
Well, it's her argument, and frankly, it seems to me it's no credit to her that she can make it, is that I'm the only person who can convince my daughter.
That's her argument. I'm the only person, yes. That's it. And given that valiant efforts, I describe them as that, by the local authority and the MDT over a number of years, daily requests by carers, will you take this medication? Protect you, have been refused by A. So that's where we were in January. In January, we also looked at what was important, and my learned friend, Mr. Karim, came up this time with four new issues of magnetic importance. However, at paragraph 78, the judge says it is the refusal to accept treatment that was described by Mr. Karim KC for the official solicitor as of magnetic importance. And clearly, in my submission, that was correct. A voluntary HRT would change the life of A. At paragraph 65:10, the judge says the best outcome would be for A to agree to take HRT voluntarily. All attempts to persuade her to do so have failed. The aim was to ensure that, insofar as possible, that magnetic issue was addressed at this hearing. So the issue was there. It always was. How are we going to get her to change her life? And if we look at the position statements of the various parties before the hearing, the local authority position statement has no proposal to end COVID, to end the covert medication, or to get voluntary HRT. There's nothing there. The local authority position was...
Well, I thought that was the local authority position you were just telling us.
No, the local authority had brought her into care in order...
No, I thought you said the local authority position statement had no proposal.
No new proposal.
Yes. And then I thought you were moving to another party, but you referred to them as the local authority. Perhaps I just misunderstood your emphasis. You're still talking about the local authority, right?
I'm still talking about the local
Yes, I see.
authority.
I probably
I'm going to
misunderstood
move
your emphasis.
to other parties in a moment.
Okay.
As far as the local authority is concerned, and their skeleton argument is in the supplementary bundle at 1 to 15, that there is nothing there about how covert medication can be ended or how you can get A to voluntarily take HRT. And therefore, the only conclusion is that the local authority position was keep A in care with a deprivation of liberty and covertly medicate her. Because there was no exit.
There's some understanding, forgive me for talking over you. So I saw references to the fact that the current placement was not considered to be a long-term option. Could you remind us of why that was the thinking?
That was the thinking of the local authority.
Yes, why was that their thinking?
I can't answer that question.
Very well.
Because it was something the local authority put forward. I don't think we ever quite explored why. Clearly, the position was that A had been there 5 years.
Yes, I understand, but the local authority's plan, as understood by the judge, was that of the currently available options, one was going home, one was staying where she was for the time being until the semi-independent living option could be developed.
Correct.
But so the judge only had those two options in mind, but he was aware that one of them was not considered to be a permanent option, because there would be a move in care, potentially.
The local authority had indicated that it did not regard the care home as a permanent option. That's correct. I can't take it any further than there. My Lord puts to me that it wasn't a permanent option. I can't say that it wasn't. I just say the local authority said that its view was that it wasn't. And that wasn't in dispute during the course of the hearing.
Thank you.
So I can't take that any further. Turning now to the trust position statement, which is obviously clearly relevant. If we look in the supplementary bundle at page 85, the position of the trust at that stage is set out there very candidly and clearly. It accurately reads, there's no dispute about any of this, that paragraph 35, so it's page 85 of the supplementary bundle, A will not take the medication voluntarily at this stage. The last witness statement of the official solicitor records that A does not accept that she has primary ovarian insufficiency. A has made it clear that she does not accept there is any need for her to take the medication. Numerous attempts have been made by a number of professionals to have discussions with A and encourage her to voluntarily take the medication. It has so far failed. And the next paragraph, as pointed out above, and since the orders made in June 2019 by Her Honour Judge Moya, A has received regular input to seek to educate her about underlying POI. That educational input has not resulted in any change of A's understanding in relation to the maintenance and medication or her views. And then paragraph 39 sets out B's position, which is that B maintains that a second opinion should be sourced, not because she wishes to have it, but because A wishes to have this opinion. It appears that B wishes to be involved in the search for that alternative clinician and sees that search as being part of the overall plan to seek to persuade A to voluntarily take the maintenance medication. No dispute with any of that. But no proposal. No new proposal in the trust skeleton to move to voluntary taking of HRT. And of course, the OS skeleton was not in the business of making new proposals for the trust or for the local authority or for the MDT for that matter. So that was not covered. But what the trust said was what the position was, that the judge was faced with a very difficult situation. Serious efforts had failed. There's no better way of summing it up. They just failed. So this was a complex case. So the question is, what was to be done? And Mr. Karim, in his position statement at the hearing, described the matter as beleaguered with complexity. That's at paragraph 2, page 26 of the supplementary bundle. And this is clearly correct. It was beleaguered at that point, at the start of that hearing, with complexity. How do we get A to take HRT? Does she reside at home or in a care home? If she is in the care home, is she going to be covertly medicated? And if so, for how long? Is it going to be years, or is there going to be an exit plan? Because there was no exit plan.
It had been October 2022, so 15 months before this hearing. The court had said there must now be a plan for covert medication.
Yes.
To consider how she might be brought off covert medication. So that was, from the point of view of the court authorising this very abnormal situation, was bound to be a driver to its thinking, because there was unfinished business in relation to this continued daily...
Yes. And there was no plan.
I don't think the judge makes any finding, or one can't tell, and we haven't been enlightened in the submissions as to why that wasn't, no plan was created.
What happened was that there was a plan for education of A, and that was regarded as the exit plan,
yes, I see.
As far as the MDT was concerned.
Yes, I see.
And it wasn't...
There wasn't a further bit. What do we do if the education doesn't work?
Yes.
So the submissions that you're making about where everybody stood at the beginning of January got to be seen in the context of the fact that this was a problem that had been identified by the court over a year previously.
Yes.
And all attempts to solve it had thus far failed.
Indeed, and more than that, because plenty of time had been given. In September 2022, B was told about the covert medication, and there was, from November, some element of contact starting. But there was still, by January of 2024, over a year had gone by, and still there'd been no progress. And in that time, there had been efforts, and we could go into the criticism of those efforts, but there's no point in doing that. There's no doubt that people had seriously tried to convince A, and that this had not been done, not succeeded. But the aim of this hearing was to bring together the issues so that there was a focus on what happens next, so that we could plan what happens next. So the judge was making the big decisions. His decisions are set out as declarations, in effect. This is what should happen. And then the Section 16 final decisions were for a future hearing. Whether it was right to make declarations like that, certainly that was something that was the judge understood that this was setting out the narrowing of the options available so that we all knew where we were going and could make a plan. B's position on the magnetic issue, getting her to take it, is known. And as far as the learned judge is concerned, at paragraph 80, he was looking for the best possible outcome for A. Is there a positive outcome? And the answer to that in my submission is it's possible to see that from the judgment. So what is the possible outcome? It is that A is at home. As the judge says at paragraph 80, her relationship with B and her grandmother is the family life that A knows and to which she strongly wants to return. B might succeed in convincing her to take HRT voluntarily, She should be attending her GP and also seeing an endocrine consultant. The GP and B will monitor the epilepsy medication and the vitamin D medication, which A currently takes regularly, and see if they can convince her to take HRT, and if they can, then they will have to monitor that as well. There would be weekly trips out with the support workers from the local authority, which B would hope would be a positive experience. And B also accepts that she didn't do well with positive engagement in the past, and that she needs to work very hard at it. And she also knows, if we look at each of these outcomes, and they include one I should mention, which is that A gets some exercise because she's overweight and she's not getting out at all and spending apparently quite large amounts of time in bed. And mother is very concerned by that and would want her to get some exercise. So all of these are things that are workable, they are deliverable, they are possible. The judge is sceptical whether they will be delivered as a whole for reasons which we'll have to divine from the judgment, but they are not something which is unworkable, and certainly on any reading it would be a positive outcome for A. As my learned friend Miss Joseph O'Brien said, if she is convinced to take the HRT, there would be no reason for her to be continued to be deprived of her liberty to this extent in the future. And what's the alternative? The alternative before the court at that time was an indefinite dole in institutional care of one kind or another, probably a more draconian dole, because the social worker suggested, see page 22, paragraph 81, that she was going to have to consider ending, or at least suspending, contact with mother if there was a move to independent supported living. As it says, it would probably serve no useful purpose for the court, and if the court did not also declare that it was in her best interest to make that new start in the absence of contact with her mother. So a more draconian dole was in prospect. And covert medication indefinitely, because there was no clear exit plan, except we hope one day she will break and be convinced and care. So what would happen to A in terms of contact with family and friends at the bowling club or wherever? Probably more isolation, because one of the concerns of the judge is that if mother's hope that daughter would return home is taken away, perhaps mother's decision that she is not going to tell A about the covert medication might change. B says not, but that was the concern of the judge. And that other family members might say something. So there would have to be ongoing restrictions of contact indefinitely. This is not for the next 5 years, this is for decades. So that was the serious situation faced by the judge at this hearing. And he also had to ask himself the question, well, if after 5 years they haven't convinced her, are they ever going to do it? And who is the indispensable person in all this? It's mother. And mother's best place to get her to take it. As the learned judge said at paragraph 80, hence if A does not return home now, she may very well be accommodated away from home, separated from her mother, against her strong wishes for the foreseeable future. The influence B has over A has apparently survived, all attempts to dismantle it over the past few years. It is entrenched and cannot be wished away. Consequently, the issue for the judge is, if this is going to be the situation, how can we use it positively for A? Let me just say a brief word on capacity. As far as the hearing in January was concerned, there was no issue of capacity. There's been discussion about whether B's position has changed. B's position has changed on capacity. She thought her daughter had capacity in 2019, and she accepts the decision of the court and said that in January, and indeed she has been saying so since 2021, the end of 2021. Certainly that's when I began representing her. And therefore, I can't speak before that, but certainly we know that at the hearings with Her Honour Judge Moyer, she thought her daughter had capacity. But she now accepts that is not the case. She accepts the facts, and facts are wonderful things because people have to look at them with care. Of course, the famous economist John Maynard Keynes said, when asked, Mr. Keynes, have you changed your mind about something? Well, when the facts change, I change my mind. What do you do, sir? And B was faced with that situation. B accepts that her daughter has a learning disability and lacks capacity. That's a fact. She accepts that this means that she has got to adopt a different view. When her daughter says, I want something, she's got to say, well, that may not be in your best interest. The trust has suggested that B has not changed her mind on capacity. She's changed her mind for 2 years, and it's time to catch up with that. So there have been a number of changes of mind by B. She changed her mind on the need for a second opinion. Everyone now agrees there needs to be a second opinion, but for a period of time she said, well, I'm happy to have one, but it's not for me. And she also changed her mind on the morning of the hearing, saying that if it's necessary for covert medication to be delivered in the community, then I'm happy for that to be done. I'd rather it wasn't done in my home because of the OCD, but if necessary, that's an option. But I would prefer it done elsewhere, perhaps in grandmother's, or done by the support workers taking my daughter for lunch every day. Now, the judge thought none of those options were practical, and in retrospect, looking at the judge's view of them, B had always put forward those 3 propositions as a short-term measure until she convinced her daughter to take HRT. And as a short-term measure, maybe they were practical. But as the judge points out, they're not practical in the long term. And if the judge's view was it was unlikely that A would be easily convinced to take HRT, then in the long term, it is difficult to gainsay the judge's view that these weren't practical options. Can I now? And I saw my lord. I thought my lord was going to say something.
Well, I didn't, I'm afraid, make a note beforehand of your of the path you were taking, but for a little while I got the impression you were really just making the kind of submissions you made to the judge. I haven't understood which of the particular issues for us you're focusing on.
What I'm focusing on is 2 things. One, that the judge needed to narrow the issues, not let the case drift. And
well, you've made that point.
Yeah,
yes.
I've made that point. And the second point was that as far as the judge was concerned, these were the options facing him, and they were very difficult options indeed.
Well, I think that's common ground. But anyway,
yeah.
Anyway, where are you going next?
I'm going next to the legal framework and looking at the way in which the judge looked at the law, which in my submission was very clear and...
Well, it hasn't really been very much challenged, that, as Mr. Karim said he should have looked at the Human Rights Act or the European Convention, but
yes,
it's not been suggested that the judge misdirected himself about the legal framework.
if it is the case that, as far as the legal framework is concerned, the judge was correct throughout, then I thought there were some issues that the judge had erred. But
well, yes, but not well, it depends what you mean by legal framework. But I mean, I don't think it's erred. He erred because he's reached conclusions which were said not to be open to him, or he didn't have regard to particular factors.
yes.
But the legal framework, in the sense I would normally understand it, of what he had to do under the Act and so on, is not really an issue, is it?
I hope that it is not, and if it is not, then the judge was correct in terms of the way he directed himself in law. The case law that he referred to certainly identified some of the key issues, and therefore, in my submission, that was he was correct throughout, and particularly in terms of
I think it would help the court if you focused on the criticisms that are being made of the judge's approach.
Yes, one of the criticisms is the amount of weight given to wishes and feelings and the values. Because remember that we're dealing not just in Section 4 with wishes and feelings, we're also dealing with values. Section 4 says that the judge has to take into account the values of an individual as well as their wishes and feelings. And values come in all shapes and sizes, including family as a value. Yes, as my lord pointed out earlier, there are issues around wishes and feelings, and people feel, I want to be with X. I want to be, in this case, with my mother. But as far as values are concerned, what does a value? She values clearly family. That's her value. And so the judge has to look not only at her wishes and feelings, but also the value. And
I'd forgotten that the judge placed weight on values, but I'm sure he did.
Yes.
Where do we see that?
We don't see it specifically mentioned, but
No,
the judge...
I was thinking that's a very good submission, but I don't find any reference in the judgment to it.
My submission is the judge, if he had referred to it, would have been quite right to
yes,
do
but
so.
I mean, can we move towards the things that are in issue here, rather than points that the judge might have...
One of the things that the judge was referred to about the wishes and feelings, and I'm not going to take the court all the way through this, but was the discussion that took place between A and the official solicitor. If my lords have had the opportunity to read that exchange, it is...
Not only had it, but taken it, yes.
Yes, and that exchange demonstrates the vulnerability of the individual involved, the clarity with which she articulates her views, the level of confusion sometimes with which she articulates it, but the level of upset. And the word misery might be something which would be apt to describe the reaction. This is a young woman in misery where she is, and she wants that changed, and therefore, as far as the judge was concerned, that particular exchange with the official solicitor was drawn to his attention, and it's something that I would urge the court to read, to understand the depth of the not only wishes and feelings, but also the depth of the values which and the misery faced by this young woman. Let me turn then to the evidence in relation to covert medication. I've also already mentioned some of it and what was...
Well, again, I mean, help me... already say you're turning to the evidence about it. What particular point are you addressing that you have to meet on this appeal? So I can understand where you're going with it.
Where I'm going to is to look at the consequences of ending covert medication. And the evidence that was before the court and which was referred to in the judgment from Dr. X about the consequences.
Yes, well, speaking for myself, I'm very well aware of that, and it is as far as everybody suggested, it isn't accurately summarised by the judge.
Yes, it is accurately summarised. The importance is the difference between short-term, long-term, and medium-term.
Yes.
And the extent to which the stopping of covert medication.
I'm sorry to be picky. You mean stopping of medication?
Stopping of
I mean, it is covert, but you're not making a point about covertness. You're making a point about
stopping
medication.
Of medication.
Yeah.
Indeed. The extent to which the stopping of medication would produce a clinical consequence, because clearly that's a matter that would weigh heavily with the judge.
Yes.
And the judge summarised that. The short-term consequences were hot sweats and night sweats and flushes. And there would be an immediate effect on bone density. But that would be slow. Bone density is measured, as we had evidence, it's not in the judgment, but we heard evidence it's measured in 3 yearly intervals, otherwise it wouldn't be measured. And the sorts of consequences for A would be the sort of consequences for somebody who has the menopause, a woman who has the menopause. And that would just happen early. It would happen as soon as the HRT was stopped. However, bone density, as we heard in evidence, improves up to the age of about 30. And therefore, there is a certain trade-off here. So this is one of the points that came out in evidence. It's not in the judgment as such. But as far as Dr. X accepted that bone density improves up to the age of 30, and therefore, if you stopped taking HRT, then bone density would immediately be affected and would immediately start to deteriorate. But if you started again within a reasonable time, that would be mitigated, not least by the fact that she's under 30 at the moment. So there was the nuances of the evidence were more than I think appeared in the judgment. But the judge would have been well aware of this, because the issue of stopping medication and the issue of what the consequences of this would be was canvassed at some length with Dr.
Yes, well, everything you've said, I've seen the material already. Indeed, the judge makes the point, I think, or perhaps somebody makes the point that the short-term consequences might be a reason why, because they will be disagreeable, but not in any way life-threatening, and if they eventuate, because they don't eventuate in every case, might be a reason why she decides to take HRT after.
Yes. And so my short point is that in this judgment, the learned judge considered the level of risk to life and well-being in some detail, and it was a significant part of the evidence. And when we look at Article 3 and Article 2, as far as the obligations under those articles are concerned, the question is, has the state conducted a serious investigation into the level of risk posed to the individual by these steps? So the state clearly is responsible for a decision in best interest to cease HRT. Has the state conducted an investigation into the level of risk this poses to A? And the answer to that question in my submission was during the course of the hearing, the judge looked at this, his judgment deals with it, and the cross-examination of Dr. X addressed it in some detail.
Yes.
And there were reports before the judge on it. So therefore, in terms of Article 2 and 3, the issues of life and injury, harm being caused to individuals, the obligation on the state here is to conduct an investigation.
So you've said
it
yes,
was done.
and you say it's been discharged.
It was discharged. So that certainly is my submission. Let me deal with this issue of the apology. I think the Lord, to some extent, has addressed it, but I'm instructed by my instructing solicitor that a further apology has actually been given.
Well, we can't deal with that. We can't deal with
No,
instructions.
you can't. I accept we're dealing with an appeal from a January hearing. But as far as B is concerned, it's not an issue. She will apologise for the fact that she should have convinced her daughter in 2019, 2018, in fact, to take HRT, and she didn't do it. She thought at that stage her daughter had capacity. She now accepts that it didn't. She accepts that she was wrong, and therefore the circumstances have changed. So as far as an apology is concerned, that is not an issue. I know my Lord has already seen the reference that was in my submission to this court about when the apology that was given. There is no issue about repeating it. What I would say, however, is this. Having an apology being given once and having it had no effect, that was known to the judge. And indeed, it was referred to in my submission. So he was aware of it. There had been an apology. The position of the official solicitor is that Dr. X said there should be an apology. I don't know whether when he gave evidence, Dr. X was aware at that time that there had been an apology and it had no effect. I don't know the answer to that. But as far as giving an apology is concerned, it had no effect last time, and it's not a strong argument that another apology has to be given. The other argument, of course, is that perhaps A should be able to see have the second opinion. The poignant second opinion, I think is the word I used in my submission.
So what was the
second opinion?
What was the adjective?
Poignant.
Poignant.
In the sense that this young woman was detained for 5 years, deprived of her liberty. At that stage, she said she wanted a second opinion. Anyway, everyone now agrees a second opinion would potentially help because she's still saying the same thing. So we have got to the stage where she may get what she wants. There have been difficulties in making arrangements. It was fairly described by my learned friend for the local authority. So the issues there are still being managed. But as far as getting a second opinion is concerned, we don't need to delay a decision on everything else in order to get a second opinion. There's no issue about whether we get a second opinion. So whether it's done before A moves into the home, into her own home, or whether it's done afterwards is not an important issue. The issue is, does it work? And as we've already heard from the trust, if she's going to take HRT and this second opinion works, then there's no reason to continue the level of detention. So that's how I would deal with that point from the OS, that either of these, either the apology or the second opinion, must happen first. As far as paragraph 73 of the judgment, and I'm now moving to the issue of the return home, having dealt with some of the issues around covert medication. As far as paragraph 73 is concerned, that's the best interest assessment. In my submission, this assessment is logical and clear and precise about the reasons why the judgment was reached. And it shows clearly the reasoning of the judge. And my lords will have read it with a great deal of care, so I won't go through it again. But my submission there is that this is a judge who has weighed the evidence in a very difficult decision, taken the view that there's no easy way forward, and has reached a clear conclusion that it is in the best interests of A to move forward after all this time. Let's look at the arguments now, and I move to the particular grounds being advanced by the various parties. Conscious of the time, so I'll move through these hopefully fairly quickly. The first ground is that the judge decided on best interests on a final basis when no party asked for this. Well, he hasn't decided on a final basis. He's made declarations about what's in her best interests, narrowed the issues, and the final decisions will come later. As to what
Is that right?
Well, the big issues have been resolved.
Well, he has effectively, he hasn't issued an order, but for all practical purposes, the effect of his order is that, subject to working out the details, she will return home.
Yes.
And covert medication will be stopped.
Yes.
And she will be told that it has happened. Now, those are final decisions.
Those are final decisions.
Well, those are the one. That's the point that he's been said to be wrong.
Yes. My submission is that all the parties knew, and we can look at the order of the 9th of October 2023, which is in the supplementary bundle at 289, and that says quite clearly, next hearing, paragraph 15, there shall be an in-person final hearing before Mr. Justice Poole, sitting at the family court with a time estimate of 3 days, starting on 24th January 2024, to determine...
Sorry, you've got ahead of me. 289, paragraph 15.
Yes. And then the issues are A's capacity in the domains set out. So that would be resolved. A's best interest in relation to maintenance medication. A's best interest in relation to residence, care, and contact. Now, the position statement from the local authority, which is at page 5 of the supplementary bundle, says at paragraph 17, the issues for the court to determine at this hearing are medication, residence and care, contact, A's contact.
Sorry, where are you reading from?
I'm reading from supplementary bundle, page 5.
Page 5, yes, thank you.
Paragraph 17.
Yes, thank you.
Yeah. The issues for the court to determine at this hearing are medication, residence, care, A's contact with B if A and B are not to reside together. So it was clear that a return home was contemplated because it says if A and B are not to reside together. And the supplement at page 25 is a chronology, and the last part of the chronology says final hearing, medication, residence, care and contact, 24th of the 1st, 2020.
But I think the case against you is that whatever you may have said in general terms in the position statements, it became clear at the hearing, or shortly before the hearing, that your case was based on a trial period only.
Yes, indeed. That, there were 4 options canvassed by B. As far as the draft order was concerned, the local authority had said that it was concerned that there wasn't an order, so I provided an order. It had the favoured option of B, but it was clear that that was one of a number of options.
But hang on, that was after the hearing. I think what is being said
is
that in advance of the hearing, I forget the exact timing, but the hearing was conducted on the basis that your case was trial period.
Yes.
And as you say, you in due course produced an order after the hearing, which was consistent with that, and closing submissions consistent with that. But the point is that that is not the order that the judge made.
No.
And that he therefore was deprived of the benefit of any submissions, and indeed, insofar as relevant, examination of the evidence, on the issue of whether the order which he in fact made, which didn't involve a trial period, was the right order. Do you have anything to say about that?
Yes. If we look at the judgment in 7th of October 2022, we'll see that, if I can find my note on that, the judge then had indicated his views about ending. In fact, he said it at paragraph 2 of this judgment, that he wanted to look at ending covert medication and wanted a plan to do that. So it was very clear from the start that the judge was considering this issue, ending covert medication and returning A to her home to live with B. Those were the issues that were before the court. They were issues on which B's representatives made representations. A's representative didn't make those representations, and neither did the local authority. Now, I don't doubt what Muller and Friend said is they didn't think it was an issue, but if we go back to the judgment on the 7th of October 2022, the judge was then flagging that these were issues which concerned him.
What was the paragraph in the 2022 judgment?
I'll have to look at that up, my lord.
You just gave a paragraph reference, I thought.
I think you gave a paragraph reference to the order, or perhaps Jerry wanted the judgment.
Yes, if we look at paragraph 30, which is 206, we see the judge there says, as to the risk of discovery of covert medication, it is surprising it has not already happened. And then he goes on to the reasons why he is concerned. And then if we look at paragraph 38, at the bottom of paragraph 38, it says, A's best interests are served by exploring the most effective way of transitioning from covert to overt medication, or ending covert medication in a way that is likely to cause the least harm to A. This needs to be a controlled process if possible. The reasons why the covert medication plan was authorised in 2020 are sound, for the very success of covert hormone treatment plan has created the problem of how to end it with the least harm to A. And then paragraph 42, the medical advice is the best health benefits to A are from lifelong maintenance hormone treatment, but in my judgment it would be extremely difficult, if not impossible, to sustain the covert medication plan in the long term. However, it would be even more difficult to continue the plan without the fully informed cooperation of B, if B were to discover, etc. And then, if we look at paragraph 45 at the bottom of that page, it starts and goes on to the next page. There is a substantial ongoing risk that A will discover that she has been and is being covertly medicated.
Are we still on the point that we were asking about, which is what the judge made clear that he would be looking at?
Yes, we are, because what the judge is saying here is, this is what I'm concerned about.
You're saying effectively this point has been up in lights for over a year.
Yes, exactly. Everyone at that
So
hearing...
if we get past the fact that you asked for 12 weeks or 6 weeks or whatever it was.
Yes. As far as the trial was concerned, mother was always very clear she wanted her daughter home permanently.
I was moving past the trial issue,
Yes.
then moving past the cessation of covert medication issue, which you now addressed us on. That left the telling A issue,
Yes.
which is the subject of one of the later paragraphs of the existing judgment, where he sets out his thinking, which needed to be considered by the parties, about the sequencing of a return home and what A should be told at what stage she should be told.
Yes. Clearly, once A goes home, there is a substantial risk, certainly the local authority and others would have been concerned about it, that B would tell A that she'd been covertly medicated if it was the case that covert medication had not stopped. So if it was ongoing, sorry, the logic is if it was continuing, B would not tell her daughter, but if it was stopped, then there was a risk she would. Yes?
Well, surely the questions are, perhaps I'm losing myself. First, do you, as far as covert medication is first, do you stop covert medication? Secondly, which doesn't logically follow from the first, though it may in practice follow the first, do you tell A it's been stopped? You don't have to tell her.
Well, there will be change. Sorry, my lord, I interrupted.
The risk is that she will then suffer consequences of it being stopped, and it had to be explained to her why.
Yes.
Or even if it doesn't have to be explained to her why, it may come out why, one way or another.
Exactly.
So the judge clearly took the view, once you've made the decision to stop it, it isn't open to you not to say it's been stopped.
Yes.
Now, was that last point also flagged up to the parties in advance?
It was an issue that was, should we tell A?
This is the minefield.
This is
it's the doctor's minefield.
Yes.
Treading on a mine. And
yes.
The judge, it's the one point at which he specifically disagrees with
he does.
Dr. X.
Exactly. Yes, yes, my lord is well ahead of me and has gone directly to that point. 64. Yes, 64. And he does, as and it is a point that there was a misprint in the original draft, so which had to be corrected. So I should have gone to that myself immediately, because yes, the learned judge clearly considered this in some detail, and it was raised with Dr. X, and Dr. X, this was on cross-examination from me, expressed a view that this was telling her it was like walking into a minefield. But as far as the judge was concerned, there was no need, there was no way this could be avoided. And he goes through in the next 3 paragraphs setting out.
Yes, but I'm sorry to be very narrow about this.
Yes.
It looked as though this point was canvassed with Dr. X.
Yes.
So the issue we're on at the moment is whether
we should tell her.
No. The issue we're on at the moment is whether the judge took a course which he'd not had the benefit of evidence and submissions on. And one of the courses that he took was to say she should be told. What judgment of Power 64 shows is that this point had in fact been canvassed in evidence.
Yes. Yes, that's what it does show. Because Dr. X clearly didn't want to tell her anything or to end covert medication. And so that issue was canvassed. It was.
Okay, thank you. Sorry, I mean, you may want to make other points about it. I just want to keep our eye on the particular ball we were on here.
Yes.
Yeah, thank you.
So in those circumstances, as far as what the judge decided, these issues were being canvassed during the course of the hearing. They weren't always being canvassed by others, but they were certainly being canvassed in cross-examination by B's representative, myself. And so these issues were being raised, and the judge addressed them in the course of the judgment. Let me move to the issue of the oral submissions, which is the next ground being advanced. There was a lack of opportunity for oral submissions. Well, the parties agreed to that. Oral submissions in court are often constrained by the clock. So there isn't always the time for these very good exchanges, which judges and experienced advocates sometimes have.
You won't persuade me that it's good that that's the case.
No, I'm not seeking to convince my lord that it's good. I'm seeking to convince my lord only of the point that
more time can be made. You have to have another hearing. It happens. This used to be a regular problem in the employment tribunals until the Employment Appeal Tribunal said something about it. That we'll have written submissions later, and the Employment Appeal Tribunal said this is in a difficult case. This is not a good idea, and if you really want to go down that route, you'll have to schedule another hearing.
Yeah, I'm also aware that this court has criticised judges for delays. There are always going to be time constraints. Yes, it would be helpful to have exchanges between judges and experienced advocates, but judges take different views about how they deal with submissions. Some judges take the view that they will let the advocates make their submission and listen to them and engage from time to time, but let the advocates make the submission. Other judges take the view that it is more of an iterative process, an engagement between the advocates and the judge. Judges have lots of different views about how they do these things. Nobody suggests that there has to be a particular collaborative approach. First I've heard of it was from the local authority appeal. Yes, collaboration is good. Yes, that sort of engagement is helpful, but it's not always useful. It's not always usual.
Mr. Joseph Brown came to three particular points that he said might have been of particular value to the judge to have heard you all about. The first was dolls at home. The second was...
Sorry, I didn't quite catch that.
The dolls at home.
The dolls at home, yes.
Sorry, that was the second one. The first was the MDT. The second was the dolls at home. And the third, effectively, was the nature of the services that could or could not be provided following a return home. Now, those I took to be the 3 points that he said would have been valuable submissions about those. What's your response to that submission?
The position of the MDT was very clear as far as the attitude towards B. B was regarded entirely as a risk, and that risk could not be managed. And as far as the MDT was concerned, there were two representatives who gave evidence. Their evidence was consistent one with the other. As far as the key issues were concerned, that there should not be a return home and covert medication should continue. The views of the MDT were canvassed. Should the MDT have known that the judge was going to come down on a particular position? Well, the MDT, the whole objective of this was to narrow the issues. So the MDT could then deal with the direction in which this matter was going to go. So the objective of the hearing in January was so that the MDT and everyone else knew where we were going with this case. As far as the dolls at home was concerned, a community doll was always going to be, this is an experienced judge. The judge would have known this, and so would the other parties, all of whom are experienced in the Court of Protection, that if you send someone home and you are considering covert medication, the only way you're going to be able to do that is with a community doll, because of the nature of it. Also, if there are going to be restrictions on the liberty of A when she goes home, then the acid test is going to be met. And so a community doll, did it have to be explored and the detail of the nature of it? That wasn't the objective of the January hearing. The January hearing was in order to identify the route on which we were going and narrow down the issues so that we could then focus on whether it was necessary to go through the detail of how that doll would operate. Because before the hearing in January, we could have had all sorts of dolls. Dolls in care, dolls with covert medication, without covert. We didn't know what was going to happen. Now we're in the position where all the parties know, the judge has taken a view, this is the direction of travel, this is where this case is going. Now we've got to work out with the MDT, with the local authority, with others, what level of particular care is going to be available to P, in this case A, in the community. And that was always the objective that the judge delivered on in January, to narrow down the issues. As far as the services available are concerned, this judge will have known what sort of services are commonly available in court of protection cases, and what local authorities are capable of doing and what they're not. This judge was well aware of the risks in relation to B. This judge, he set them out in a lot of detail. This judge was aware that the local authority would have to provide some support so that A was taken out into the community, and that would be being done weekly at least. We've already heard that the proposal is in fact for 3 times a week from the local authority. B knew that level of support would be provided. That level of support would require that A actually goes on those visits. Now, there is a difficulty here, which everyone would have again been aware of, and certainly as a representative of B, I would have had to have been well aware of, and that is, does A want to go on these trips? And one of the ways in which mother would be supported in saying to A, you've got to go on these trips, A, you really have to, because the court order says you've got to. And if there was an obligation, indeed, to go even on one of these visits a week, then that would require a community doll. Was this canvassed during the course in that detail in the course of the hearing in January? No, it was not. So the detail of the orders were not canvassed because of the very need to narrow down the issues. If we were in a situation where we had to canvass the possible dolls, orders that would result from any one of the permutations where this case could have ended up, we'd have had a lot of orders.
Yeah, we have the point, yeah.
So in my submission, as far as management of medication is concerned, something I haven't addressed, that will be done by A, being monitored by mother and GP, and by also the clinicians who see her from time to time, as hopefully they regularly will. So those are my submissions on that point. So as far as the protective measures are concerned, the judge actually uses in paragraph 82 the word support, that this is support for A. So it's not meant to be protecting her from any contact with B. Obviously, A is going to be living with B and B will be the main carer. So there is no suggestion that these protective measures have got to prevent any contact between the two. That's for the past. What this is about is making sure of a limited number of things. Medical appointments are attended, that there is social engagement, and that to some extent there is a continued effort to get her to take HRT. Beyond that, the local authority says in its skeleton argument that it's in a position of uncertainty. Well, the objective of the hearing in January was to end the uncertainty. If we go back to a position where we don't know what's going to happen, then we are in some difficulty again. Moving on, the fourth and fifth grounds are that the decision that A should stop receiving covert medication and being informed. I think I've addressed that, so I won't take the court's time any further on that. Checking my note. The one issue that does cause some concern is the reference to the RCP guidance.
Well, we've said we're not going to deal with that.
Sorry?
We're at cross purposes. What point are you about?
This is the guidance referred to in the judgment by Lady Justice Theus, which was referenced in the judgment. And it was guidance from the Royal College of Psychiatrists.
We didn't hear any submissions about that, did we?
No, we didn't.
Is the short point that the wrong date was placed on it?
Yeah, but there is a further point, and it is this, that the judge is being criticised for not having checked medical references in a previous case. What he was looking at, it was the what were the issues, and he was looking at the law in the past. So he wasn't trying to identify what's the correct clinical advice from the college. He was trying to look at what was the judgment of this judge in a previous case. He was looking at the law. And the question for this tribunal is whether the judge relied overly heavily on an old piece of clinical advice.
And your point is he didn't.
He didn't, exactly. And it's in my, I won't repeat the point, it's in my submission. So that one dealt with, hopefully. I've dealt with ground 7, which is the deprivation of liberty, the community orders. And moving to ground 8, which is the prioritisation of wish and feelings over Article 2 and 3. My submission, very briefly on that, is the objective of the judge was to work out what was the level of risk. What was the level of risk if I stop covert medication? If I stop her having HRT? And he did that, he carried out the investigation, and he also had to balance this with what was the level of consequence if she was continued with covert medication and continued in care, was subject of a very onerous deprivation of liberty. And that was a balancing exercise which the judge had to undertake. And he went through that evidence with a great deal of care and came out with the judgment that he did in paragraph 82. So in my submission, the suggestion that there was undue weight given to wishes and feelings, and which of course are always a matter for the judge, about the level of weight to be given, and that there was insufficient weight given to Articles 2 and 3 is just wrong, for the reason that the judge did give a lot of consideration to investigating Articles 2 and 3 and the level of risk that was involved. So in conclusion, those then are my submissions. This judge considered these issues with great care, considered the law with great care. He had a very difficult series of judgments to make. He gave fair warning in his previous judgments and in orders leading up to this hearing in January as to what was at stake. This was always going to be a case where the future of A was at stake, and that these were very serious decisions that had to be made for there to be some progress, because the alternative was continued drift. Now, I'm sure that the local authority, the official solicitor and the trust will not regard continuing covert medication and a doll in care as drift. But as far as A is concerned, she has been left since January not knowing where she's going to be living in future. And so there is a vulnerable young woman who wants to know what the outcome of the court decisions are going to be and can she go home. My lords, my lady, you've read what she said herself. She wants to go home. That's what she told the official solicitor when they met. And she wants to know what's happening to her. And as far as the hearing in January is concerned, she's been told nothing. Not told anything by her mother, not told anything by anyone else. Just that the courts are looking at these things. So the points that were made earlier about what's going to happen next with this, and if this appeal were granted, will there just be more hearings to consider exactly the same issues as before? And if so, what would the local authority, the trust and the OS say that's any different from what they've said in the past? Covert medication should continue and she should stay in care indefinitely. The choices aren't going to change much. So what would change? In my submission, only delay. And that is not in the interest, not in the best interest of A. Those are my submissions, if I can assist the court any further.
Thank you very much.
I'm grateful.
Mr. Strollop.
My lords, my lady, I have a number of points of information to provide you with arising out of your questions.
That'd be very helpful.
Some points of substantive reply. They're about 7 in number, and they are all short, and I will keep them as brief as possible.
Yes.
By way of information, my lord, you asked about the care home and why that isn't considered by the local authority to be the most appropriate long-term place. There are 2 reasons, really. One, it's a care home, and so there is a greater degree of, if I can put it this way, having things done for you. And the point about supported independent living placement is that, which would be a different setup, would be empowerment, promotion of greater independence and the acquiring of independent living skills. None of that can easily be done on a long-term basis for A, where she is. And the other point is geographical. It is, I understand, really quite some distance from the town centre, which is the area that A is more familiar with. So if we were thinking about a supported independent living placement, it would be somewhere more towards the town centre. The lady asked about social engagement and raised a point with Mr. Michael O'Brien about social engagement in the past. I won't ask you to turn it up, but Mr. Justice Poole dealt with this and had a lot more to say about greater social engagement during the period where A did not have contact with B, when she was accommodated at placement A, and you will find that in his judgment of October 2022 at Core Bundle page 195 at paragraph 15. And the greater level of socialisation was remarked upon by Dr. X and therefore seen independently by others, and he gives some more detail in that regard. Thirdly, and this is a point that is linked to what I would like to say about the difference that testing of various final orders or decisions might have made, and I will come back to. But Mr. Michael O'Brien told you and reasserted his client's position that she does now sincerely believe that A lacks capacity to make decisions about her residence, her care, and who she has contact with. But I am afraid to say that the judge found that she, that is in very serious doubt. And the reference for that is paragraph 34.8 of the judgment. where he records what B said to him in evidence. And he says B was very reluctant to accept the evidence that A has a learning disability and Asperger's syndrome. And then he records how earlier in the proceedings, B had commissioned a report from a psychologist which identified the possibility that A has dyslexia. And then he says B's focus has been on that report. She was willing only to say, quote, "I understand that she has slight dyslexia. I accept that," unquote. He goes on to say, similarly in previous proceedings, B had described A as stubborn when A's difficulty with change is, as B must now know, due to Asperger's. And he concludes by saying that when B minimises A's difficulties in that way, B allows herself to act as if they don't exist, and so she doesn't have to take responsibility for dealing with them as A's carer.
What's that got to do with testing through submissions?
Well,
I mean, what you've just said is exactly what the judge found.
my lord, yes.
Right.
The local authority continues to be concerned.
Yes, but it's not a question of whether you agree with each other. I mean, we're concerned with whether the judge made a legal error. Yeah, so what's this got to do with testing matters through submissions? If Mr. O'Brien had made that submission to the judge, it didn't do very well, and it can be of no influence on us.
I think the practical point that arises from what might have happened differently, if we'd had an opportunity for the judge to say to us, "I am minded to return A to the care of A to the return of B, and a number of things to happen, which I will..."
This speaks of a new procedure in the Court of Protection, which is that it's like those letters that you have to send to people when you're going to mention them in public inquiries, that you should send, as it were, tell the parties, "I'm thinking of doing something." That's not how the court operates. And you appear to have several times said the judge ought to have been collaboratively telling you, "Well, my thinking has reached this point by now, and therefore what do you say about that?" That's a disastrous litigation approach.
I would, with trepidation, gently beg to differ for this reason. Cases where the judge reaches a decision which is not commended to him or advocated for by any party are few and far between, I would suggest. The best steer that we have as to the most effective way to then create a best interests framework, which is what the judge is charging us to do, I would suggest comes from the TZ decision that I've quoted from.
Lord Justice Baker makes this point in relation to a way in which matters could be dealt with, but are you suggesting that he's saying that matters have to be dealt with in that way?
I'm not suggesting that he's laying down any rule of law or procedure in that regard. What I am saying is that with the greatest of respect and acknowledging the very many difficulties that there were, and listening to Mr. Michael O'Brien saying that the outcomes were very unclear, there were so many potential outcomes, and so on, that would have been the only appropriate and effective way of enabling us to go away and create the plans.
Right, so the only effective way of dealing with this would be for the judge to, as it were, have issued what used to be a sort of an order nisi, saying this is what I'm proposing to do, and I want you now to tell me whether I can or can't do it based upon your assessment of services.
Or at
that
least,
seems to be the submission.
It's not whether he can or can't, it's more what is the least worst, which is what we're looking at in terms of best interest.
You say that the judge, in this case, had to do a staged approach.
What would have happened in the
You don't need to go that far, do you, Mr. Trollope? Surely what you're saying is if the judge was proposing a course which was minded to take a course which none of the parties had advocated for, certainly if it was sufficiently different from what they had advocated for, so that they hadn't had the opportunity to address the matters material to such a thing, he should simply get his clerk to write a letter saying, I'm looking at this option which none of the parties any further submissions in 7 days. Is that...
Yeah.
That would be a
yes.
way of doing it, wouldn't it?
As you know, the hearing went awry, so we didn't have the opportunity for the to and fro that there would have been in closing oral submissions. And therefore, I think particularly in that circumstance, the only effective way to look at the right disposal and the right decisions, as well as to look at the right best interest framework, was for there to be the sort of backwards and forwards.
I see. So, all right, but there's a strong version and a weak version of what I put to you. One is the judge's letter would say, please give me some written submissions in 7 days. The strong version is that you say the judge should not only have done that, but said, we're going to have to fix a hearing, everybody talk to their clerks and my clerk, and we'll get it on as quickly as possible. You're saying it should have been the latter.
Or one of a combination of both potentially, but something at any rate. And the reason why, and I think I've said this in written submissions, I don't think that the stronger way of convening a second hearing would have been detrimental or prejudicial to anybody, is that that's what we've ended up with in any event, except an ex post facto way of doing it, retrospectively. And if I may mention at this point, because the judge in his judgment directed, without any reference to anybody, a whole one-day hearing on a month after hand down, to do what I suggest should have been done in prospect before any final decision was made, so that he could have some submissions on how.
Well, but the difficulty with that, I suppose, is that the judge is not giving the steer that he thought it was essential the parties should have. Otherwise, he would just have more of the same. We don't think it'll work, and all the rest of it. He is basically saying, this is what I've decided will happen. Now, tell me what's the best you can do given that decision.
My lord, he did. And I think I would, again, with great respect, suggest that that is one of the ways that led him into error, because I do say, and I will explain briefly in a moment, that backwards and forwards would have had, could have had.
Well, I think that's part of the problem is that you made a tiny forensic error by saying you were actually just correcting some factual points, and you said, isn't this what you're doing at this stage of your submissions? You say you're helping
factual ones, and now I'm on to the more.
Oh, are you already? Sorry. Well, then I'm wrong. I thought that this is one of your factual points, and that you said it was going to be relevant to something you were going to say later.
My last factual point was about capacity. Mr. Michael O'Brien suggested.
I see. So, well, that's fine. Well, no harm done then. Okay. So you are now on to, well, the very question that we've just been debating.
Yes.
Well, what do you want to say would have been discussed, would have been helpful at the oral hearing?
Had he not taken them to you, I was going to take you to Mr. Michael O'Brien's closing submissions, and it's on page supplementary 121. And over to, he took you to 122 and 123.
Yes.
This is where he in his closing submissions, and I will take you through the development of this in a moment in connection with was it a final hearing or was it not point. But the last option, which was the one not preferred by B, but the one that the judge felt was the only workable option of those put forward, is to stop HRT.
So where are we? On page 1, whereabouts on 121?
That's D, right at the beginning, halfway down 122.
Yes, that's the one Mr. O'Brien took us to, yes?
Yes, and then on 123, for example, he sets out there an exchange between himself in cross-examination of Dr. X, and where Mr. O'Brien asks about what would happen if A were to stop taking HRT for 12 weeks? And the answer is the side effects of menopause that you see there. And Dr. X says he's asked if medication restarted voluntarily, it is recoverable. And Dr. X said, I wouldn't want it to be reversion therapy. And then the question is, if she got sweats and complained she could be offered medication, it could be offered, it seems cruel, but yet. My Lord and my Lady, this ties into a point that you mentioned earlier. It does seem to me that this is, had the local authority appreciated that the judge was minded or had already decided that he would make a decision to return A to the care of B, even if she were to stop HRT, then one of the things that the social worker would have wanted to look at, in what I hope you will agree are her thoughtful balancing table exercises appended to her witness statement, is the pros and cons of, if one was going to stop HRT, in the full knowledge that there might be those side effects, so that there would be an opportunity to say to A, either you're having these problems now because you've had medication and this is what happens when the medication stops, or if one was going to continue to not tell her what had been done in the past, to say, I'm sorry you're having these problems, you could take this medication or wear this patch and that would stop the problems for you, that might have been two different ways, and that could have been done at placement A rather than on a return home. And then the information could be provided to A by a support worker or the learning disability nurse who is part of the MDT, so that the information wouldn't have to be given by B. There are a number of different permutations, but I do think that this is a substantive difference that could and would have been made in terms of the choices available that could have kept open a more open future for A, if, as your lords have canvassed, the only way in which protective measures could be made effective, or if the sanction for non-compliance by B with protective measures is going to be, again, to take A away from home. And she can't ping-pong endlessly. Those would have been more proportionate steps, we would suggest, that could have been contemplated and would have been thought about, and perhaps taken back to the MDT and discussed by them.
So why can they not be thought about under the judge's regime?
Well, they could, and
the sort of things you've been talking about just recently seem to me to be exactly the sorts of things that the judge asked you to go away and think about. But and the point that's made against you is that without knowing what you've got to think about, you can't make these very fine judgments about exactly how things are done. You need to know which direction you're going. That's seems to me to in a sense, speak against the fact that the judge needed to do what you suggested. I'm sorry to ask you something about this again, but I haven't, despite the previous dialogue. I still happen to think that your solution to this, bearing in mind the situation that had been arrived at, is that the judge needed to tell you what he was thinking of doing. That's what I understood you to say earlier on. And that any just saying, come back and we'll have another hearing or exchange of emails and so forth would be of no value without the judge declaring his hand before he then went on to hear the further submissions that you might have wished to make. Have I misunderstood your submission about that?
I think if one was going to do it in that way, what would happen in the normal course of submissions, as you know, the judge would say, suppose I were minded to do X, what would you say about that? Would that be wrong? And you would get a response in that way. The alternative would be for him to say, create what you think is the best solution to a transition to cessation of covert medication now.
Well, that's what he ordered in October 2022.
He invited everybody to do their best and think about the least harmful way. And in that regard, can I say, it is not as if nothing was done in that regard.
But I mean, we've been there in terms of that being an issue that was tabled.
My Lord, you asked me for the luncheon adjournment what my client would say in terms of what it is that we're asking you to order if the appeal were to be successful. We have thought about that more over lunch and thought very carefully about the interventions that there were, and particularly a degree of judicial horror about the delay that there might be if it would be a new judge with many months in order to find time and so on. Maybe I'm putting that for dismay, perhaps. It occurs to us that one way forward might be to, in some way, I'm not quite sure what would be procedurally correct, stay, set aside, pause the implementation of the judge's final decisions, one of which is to tell A that she has been covertly medicated and for her mother to be heavily involved in doing that after a return home. To remit the matter back to Mr. Justice Poole for there to be a process that would, and these are my words and only, if I put it this way, cure what we say is the procedural defect that resulted as a result of there not being oral submissions and it not having been understood, possibly wrongly, on the part of the local authority, the official solicitor, and the NHS Trust, that cessation of covert medication forthwith was in contemplation. To have some more submissions, perhaps some more evidence, perhaps a consideration by the MDT in that regard of, for example, the sort of reversion therapy that was canvassed in cross-examination of Dr. X that one sees on page 123, and for the judge to then retake his final decision, which might be the same or might not, but at least it would be fully informed in that way. We think and hope that that would be a middle way that would involve less delay, would not involve judicial discontinuity, and certainly the local authority has no difficulty in this judge remaining involved, because we are confident that he would look again at the best interest or the final decisions with an open mind. It's not one of those cases where you feel it really does need the eyes of a fresh decision maker. But we do think that there were important matters that have final decisions missed out a stage that would have informed, perhaps different, arguably better, but certainly completely informed final decisions.
Thank you. Well, that's very clear what you're asking us to do. Where are we going next?
Very briefly, to say something about deprivation of liberty. My learned friend Mr. Michael O'Brien has very fairly said that it is his view that it was always, I think the phrase in his skeleton, and this is paragraph 50, I won't ask you to turn it up, legally evident that on return to her mother, A would be deprived of her liberty. I have to say, I disagree, and I disagree for the reasons set out in the judgment at paragraph 73, little 6.
So hang on, I may have misunderstood this. He's making a point in your favour. You're looking a gift horse in the mouth. You may well be right to, but he's making a point in your favour, or making a concession in your favour, which you think is wrong.
Not necessarily. I think what it illustrates is that I do not think the judge thought about this at all. So although it may have been legally self-evident to Mr. Michael O'Brien as a lawyer, I don't for one moment think that it was evident to be, and I don't think that it was evident to the judge, because the judge talks about a return home restoring A's liberty. And I don't think that was semantic slip of the tongue. I don't think he thought about the fact that she would need to be deprived of her liberty by her mother. And the particular circumstances of that are important and all tie up with the disposal of returning A to the care of B, who's somebody who doesn't accept that...
Can I just be clear about this? Sorry, I don't want to interrupt, but unless I see where it's going, I can't follow it. Everything you say sounds right to me, and I'm, as someone who hasn't practiced in this field, hadn't even appreciated that such a return here could potentially be a deprivation of liberty. But whether it could or it couldn't, it doesn't really matter. That's just a label. You've got to look at the substance of what her life would be like returning to be with her mother, with the power, emotional and psychological power that her mother has over her. He certainly considered all that. So, fine, but what point are you now making?
I'm sorry, we have been at cross purposes and that's my fault. The local authority's concern about deprivation of liberty and the possibly likely need for it at home doesn't arise necessarily out of the enmeshed relationship. It arises out of A's lack of capacity to make decisions about, for example, who she has contact with. We do not think
But that's not got into liberty, has it?
My lord, yes, we don't think it would be safe for her to go out of her house on her own and wander around the town centre.
But to me, that's got nothing to do with liberty.
Well,
but maybe there's not a case law. If I'd read Chesterwell, which I haven't and isn't in the bundle, maybe I've discovered that Article 5 has given liberty a much bigger meaning than...
At the moment,
yes.
A doesn't go anywhere without somebody with her. She is supervised all the time. She goes back to the care of her mother. She can leave the house at any time. There's no thought given as to whether...
So that means she has liberty.
Yes.
It might be bad for her for the reasons you give.
Well, we think that the local authority would have possibly be seriously failing in its statutory duty if it allowed her to be at liberty at home.
Yes, but I mean,
if the judge has ordered it, it wouldn't matter. I mean, nobody could...
The judge's best interest determination, a part of that, is that she will be at liberty at home.
Yeah.
We think that when he comes to think about it again, he will see that she can't be because the lack of capacity means that she can't be. So part of his reason...
Is it the case that someone without capacity can never leave the home?
No, not everybody. And of course it's specific to the individual. But as my lord said earlier, this is somebody who is at the high end of lack of capacity in a whole range of aspects of their life.
I understood my lord's observation to be the other way round. She's near the borderline of having capacity. Maybe I misunderstood that as well.
That's what I meant. I have a different problem with this particular point, which is I fail to see what the sometimes complex and counterintuitive debates that take place about deprivation of liberty at home have got to do at all with the decision that the judge was taking or the appeal that we're hearing.
No ground about it, is there?
It may be that when he says restoration of liberty, he simply means that she'll be living somewhere that she wants to be, instead of living somewhere that she doesn't.
I mean, what I don't understand is what this has got to do. The Article 5 analysis. And of course, if you say the judge said he thought he was giving her liberty, actually that was a gross misrepresentation of what's going on. He got it all wrong in his welfare analysis. We would understand, speaking for myself, that submission. But as to whether or not this young person would prove to be deprived of her liberty on a doll's assessment is for another day, isn't it? It doesn't bear upon the mental capacity assessment the judge had to take.
It bears upon the capacity is already decided.
No, the Mental Capacity Act assessment is what I meant. The Mental Capacity Act assessment under Article 4.
Yes.
It's what we're concerned with. It's got nothing to do with whether in the end the individual is or isn't deprived of her liberty. Because let's suppose she was deprived of her liberty in both places, in different ways. The judge was still going to make the same decision.
That may possibly. We don't know that. It does seem to have been part of his reasoning that she will be more at liberty at home. Rather, if he simply said she'll be deprived of her liberty there, but it matters not because it's in accordance with her wishes and feelings. But it's the final point on the ground of appeal. But do you think that she's also going to be in the care of her mother, and whether her mother will keep her safe in that regard, we don't know.
Well, anyway, thank you. Some of my woolly thinking has been clarified on that.
I think you have well in mind the fact that, well, I'm not sure, that the extent to which ceasing medication at home was on the table and fairly and squarely a point before the court. We would suggest that it simply was not. and I can take you some documents that assist with that, but I'll do that very briefly. The judge had asked, it is correct, for the MDT to, or others in 2022 to think about the least harmful way of transitioning from covert to voluntary medication. The MDT had thought about a large number of matters, from continuing education, the hope there would be in a new consultant being persuasive, looking at which it seriously did in the run-up to the hearing of the feasibility of covert medication in the community as a way, a stepping stone to voluntary medication, and obtained evidence from the GP in that regard who couldn't assist, the plans to get a second opinion, and so on and so forth. It is fair to say that no plan for transition over and above all of those, and that's not an exhaustive list, matters have been provided, in part because of the conceptual difficulty that the MDT had in drawing up a plan for something that it unanimously felt was not in A's best interests and would be harmful to her. So the judge did not have that plan. Neither was anybody asking him to make a decision that B should be told that she had been covertly medicated and for covert medication to stop. In B's opening or position statement for the start of the hearing, B said that she was neutral on A being told. The reference for that is supplementary bundle, page 47, paragraph 39. In B's closing, which was not available to the local authority at the time when they wrote their closing submissions, B seems to be saying that it's a matter for the court to decide. It's not entirely clear. It's supplementary bundle, page 128 at paragraph 32.
What was the first reference? I'm so sorry, I wrote that down wrong.
Supplementary, page 47, paragraph 39.
Thank you.
In the closing, it's page 128,
Yeah, that I've got.
32, and it's about 6 or 7 lines up from the bottom. B says she accepts there are issues with telling A. B thinks that if A is to be told, it will probably need to be done at court. It was unclear then what B was asking the court to order, but B's order, which starts at supplementary 131, on 132 in the last recital, does say it is in the best interest of A to be informed that she's being covertly medicated. And that's the first time, I think, in a closing submission filed the day after the local authority filed its closing submission, so that we had no opportunity to respond, that anybody had asked the judge to so decide. And at paragraph 11, on page 134, somewhat perhaps ironically, given that B's position is that this was a final hearing and everybody knew it was a final hearing, the draft order provides for an in-person final hearing.
Well, that's just with respect to the draftsman, reading through it, it's not a very well drafted order in various points of detail. I don't think there's much magic in.
I think that the simple point that my lady and my lords have it already, that going into it and canvassed at some time before, the parties were all in their different ways asking the judge to direct a trial, not to make final orders. Those are all of the matters I wanted to raise, unless I can assist you further.
Thank you very much, Ms. Dollop. That's been very helpful.
Just a few very brief points, my lords and lady. First, I adopt the submissions made by my learned friend of the local authority as well as the trust, and in particular the way my learned friend described if the court is minded to grant the appeal, how the matter should be remitted. Just by way of two final points, in respect of my lordship's observation that capacity was borderline,
I didn't say it was borderline.
No, it's my fault. I think I used the word borderline. Or I really just meant nearer the border, is perhaps I should have said.
Right.
Nearer the boundary. I forget what word I used, but
Yes.
I'm not sold on it.
Whichever terminology one uses, it's near to capacity, which I think what your lordship was getting at. That, in my respectful submission, is not the case. The evidence that was considered by Mr. Justice Poole in the previous decision in 2022, page 202, paragraph 18, reconsiders capacity, determines that A continues to lack capacity to make decisions in respect of all the decisions that the court is seized with, and then further, and this is a report that your lordship
That by itself doesn't negate what I suggested. There are degrees of lack of capacity. One of the cases that's quoted in the certain arguments makes that clear.
Yes.
So the fact that Mr. Justice Poole re-found there was lack of capacity in 2022, unless he said something about very severe incapacity, is neutral, isn't it?
Well, my lord, in this judgment, he hasn't considered capacity.
No, it's because everyone agreed.
Well,
but he would have been entitled to have a view about what her degree of incapacity was based on the evidence he'd heard.
Yes. Yeah, my lord, the point I'm making is that there was a further report from the consultant psychiatrist dated January 2024, which reconsidered capacity as a whole, and then, which was before Mr. Justice Poole, which concluded that by reason of the diagnoses, a continuous...
Is this in the bundle?
I don't believe it is.
Why was it before him? As you rightly pointed out, he'd already redecided capacity in 2022, so why was he given another report? Who gave it to him?
It was a joint instruction. It was a further instruction to determine whether A had regained capacity. The rationale behind that, in his first report, many years ago, before Her Honour Judge Moyer, one of the conclusions he proffered was that A may gain capacity in the future if there's a period of time when she's departed from her mother, number one, and number two, if she achieves puberty. Both those things have occurred, and so there was a re-instruction.
Yes, I'm sorry, no. I'm sure it's the first time we've heard about this, so I'm a bit confused about it. You told me, which was my understanding, that in October 2022,
yes,
he reconsidered the question of capacity and made a decision. And I just have to put my chronology I did for myself. At that stage, she'd already regained puberty, hadn't she? The stage of the hearing in October 2022.
Yes.
So if the question had to be reconsidered in the light of her having regained puberty, that would logically have been done before the hearing in October 2022.
No, after, because at that point she just gained or achieved puberty. But thereafter, the court ordered for a further report from the custody.
Oh, I see. The court ordered this further order. This further, I see, but no application was made on the back of it.
Application in the sense of?
Judge, you have already decided puberty in capacity in October 2022, but now there's this further report, please reconsider.
No. But the point I'm making, my lord, is that it can't be properly characterised as borderline or closer to the border of capacity, bearing in mind the evidence before.
Well, you wouldn't know that unless we'd seen the report from January 2024. For all I know, it says she's quite close to the capacity, but on the wrong side. Yes. Probably doesn't say that, but unless you show us, this submission goes nowhere.
Yes, my lord, it was a matter of just information that I was providing, responding to the phrase borderline or close.
I'm sorry I ever used it if it's for all this time, but there is, I'm not totally sorry, because on a common sense view, given the range of lacks of capacity that Court of Protection sees, which my Lord knows much more about than I do,
Yes.
this is not gross lack of capacity, someone who can't understand anything. And that's really all the point I personally was making.
This is a person who has a measured IQ of 65,
Yes.
who is in the category of mild learning disability, and who was described by the judge at paragraph 67 as being an adult who, whilst lacking capacity to make decisions about her own treatment, is not severely incapacitous. So we know what we're talking about.
I'd forgotten that passage, but that's the sort of point I had in mind. And you only have to look at the account of her interchanges with the official solicitor to get some sort of impression.
Yes.
Very well. I'm sorry we spent time on that as a result of my incautious use of words.
No, not at all. The final point was the observation sought in relation to a special advocate, an observation which I think my Lord made earlier this morning. Having looked at this was something that was considered before, but having re-looked at it, there is provision under the Justice and Securities Act 2013 when a court makes a declaration for closed material for the appointment to be made for a special advocate on the request of the Attorney General.
So which act is this?
The Justice and Securities Act 2013.
And does that hit the point I think everyone, is that's the general power, is it? The general power to appoint special advocates comes
Section
from that.
9 provides a general...
Yes, but I think the point was, does that apply to the Court of Protection?
No, that's the point I was going to get to.
Oh, sorry.
Not at all. It doesn't. It doesn't apply to the Family Division. It doesn't apply to the Court of Protection. The Family Division does benefit from specific guidance in relation to the appointment of special advocates. The Court of Protection doesn't.
I'm sure someone can answer this, but is there a reason?
I'm not entirely sure, my lady.
But,
Fair enough, I'm not going to take it any further.
but if there's no power to appoint to the Family Division, why is there any guidance about it? It can't be done.
My Lord, that guidance is set out if it assists in one of the cases which I was able to identify.
No, just stick to my question for the moment. I may have misunderstood what you were saying to me. I thought you were saying the power to appoint special advocates comes in the 2013 Act.
Yes.
But you said that power is not granted to judges in the Family Division
Yes.
or the Court of Protection.
Yes.
Therefore, contrary to what I must say I understood, you're saying that special advocates are not allowed in the Family Division.
But there is specific guidance set out.
Guidance where?
In the Family Division.
No, but Family Division is a court. What document? Is it guidance in the case law?
I think it's agreed with the Attorney General, but I would need to...
It's a memorandum of understanding between the Attorney General...
But what is the statutory basis?
There is none, my Lord.
So is this the position that it is agreed that for the Family Division there's what I might call a common law power to appoint a special advocate? Is that, if it's not in the 2013 Act, presumably that is the case?
It's not in the 2013 Act.
Exactly. So therefore it must be a common law.
My Lord, I haven't been able to ascertain whether the basis on which that guidance is...
I'm not going to spend time. We can get to the bottom of it later, I'm sure.
Yes. But the point is, my Lord, that there isn't any specific provision in the Court of
Precisely.
Protection. Unless I can assist you any further.
No, thank you. Well, and formally, I think, Mr. Joseph O'Brien, you have the right to reply, but you don't
I
have...
bring you very good news.
Well, that's disappointing, but not surprising.
My Lord, just very briefly, a few
Hang on.
seconds.
Well, very briefly, what?
It-
You haven't got a right of reply.
No, I haven't. I was just going to ask for permission just to make one very brief point.
Yes, I see. Okay.
And the one very brief point is my learned friend rightly drew attention to page 47, paragraph 39, and perhaps my lords and my lady would like to look at paragraph 40 as well, which is also relevant. That's page 47, the supplementary bundle, in relation to telling A. It may, on the last point that my Lord was raising about special advocates, be worth being aware of Re P, discharge of a party, 2021 EWCA Civ 512, where Lord Justice Baker suggested, I quote, paragraph 51, that there should, in circumstances such as these, be special advocates. So it was more a recommendation that that consideration should be considered in circumstances perhaps where a party was discharged from participating in proceedings, as of course happened in this case. So I made no further point, just that's where some of this comes from, and it has been recommended in the past by Lord Justice Baker. And if I had been giving advice on guidance to this court, which I know I'm not, I would have thought that was very good advice. Grateful.
Well, we're very grateful to all the advocates and those behind them and supporting them for their helpful submissions in this difficult case. We will, of course, be reserving our decision, though, of course, we'll try not to do so for too long. In due course, we will circulate draft judgments in the usual way to counsel for the well-known purposes which are set out in the Counsel General for Wales case, and only for those purposes which affects, obviously, who they can then be shown to. I'm not going to, at this hour of the afternoon, summarise all that. You're all very familiar with them. Nor will I, yeah, I'll just leave it there. I think I can't bring myself to go through all the stuff about typographical errors and so on. Thank you very much.
Thank you. Court rise.